I'm from the Sheriff's Office.
Take a look at it.
They sure are heavy sometimes, aren't they?
On February 23, 2017, in Blount County, Alabama, a courthouse encounter spiraled into a heated legal confrontation. The central figures, Lloyd Edwards, facing a protective order, his attorneys, Victor Revelle and Megan Garcia, and deputies Ashworth and Ratliff from the Blount County Sheriff's Office. A search warrant for Edwards' cell phones became the focal point, challenging the balance between legal authority and individual rights in a scenario fraught with implications. At the heart of Blount County, Alabama, the courthouse halls echoed with the footsteps of Lloyd Edwards and his attorneys, Victor Revelle and Megan Garcia, on February 23, 2017. They gathered for a critical hearing concerning a protective order filed by Edwards' wife, Jasmine.
I'm from the Sheriff's Office.
Take a look at it.
Do you have any other weapons on your person at this time that I need to know about or say?
No, sir.
No
I
knife?
do in the car.
Okay. What do you have in the automobile?
A small pistol.
Okay. Your vehicle is also part of this search. Okay. So I'm going to have to ask you, do you have the keys to your automobile?
Yes, sir.
I need the keys to your automobile right now. Okay. Let me pat you down, make sure you don't have any other weapon. Just for your safety and ours.
Amidst the legal proceedings, a subtle yet key exchange occurred. Edwards discreetly handed over 2 of his 3 cell phones to Revelle. These devices, potential repositories of evidence, were poised to play a significant role in Edwards' defense. The transfer of the phones was not merely incidental, it was strategic. Revelle and Garcia, well versed in the art of legal defense, recognized the potential value these electronic witnesses held. Amidst allegations of abuse leveled against Edwards by his wife, these phones harbored information that could tilt the scales of justice. Revelle had reason to believe that the contents of these devices could exonerate Edwards, countering the claims of abuse with evidence of consensual interactions. As Revelle and Garcia exited the courthouse with Edwards in tow, the atmosphere was tense yet hopeful. Garcia securely placed the phones in her briefcase, a move that was to have unforeseen consequences. Little did they know,
Phones to his attorney, one, and they handed it to another, and it's in the satchel that is right here.
Well, are we being detained?
At this moment in time,
They're not denying it. We have it
I'm
on
going
video.
to detain you until we determine the next course of action. Give me
Well,
just a minute.
what I have is
Okay.
person and vehicle.
their actions within the solemn walls of the courthouse were about to ignite a confrontation of legal and ethical dimensions. The decision to take possession of the phones was more than a mere legal tactic. It was a statement of trust and responsibility. Edwards, stuck in a personal and legal crisis, entrusted his attorneys with not just his phones, but his side of the story. For Revelle and Garcia, the phones were not just electronic devices. They were gateways to truth, holding evidence crucial to defending their client's innocence. Edwards, flanked by his attorneys, Victor Revelle and Megan Garcia, found himself at the vortex of this brewing storm. The focus of the deputies' interest quickly zeroed in on Edwards' cell phones, now in the possession of his attorneys. The warrant, however, was explicit. It authorized a search of Edwards and his vehicle, but said nothing of his attorneys or their belongings. Revelle and Garcia, aware of the legal sanctity of the attorney-client privilege, stood firm. They argued that the phones, now part of their legal briefcase, were beyond the reach of the warrant. The deputies,
So you're going to, well, okay. Well, we're not going to give you we're not going to give you anything that's on our person that you don't have a right to. So if you detain us, you have to have, there's certain constitutional safeguards to do that. But you're going to detain us, then hey, we're not going to run. So, and you all are telling us we are being detained. Is that right, Officer Rapp?
At this point in time right now, you are being detained. Now, if they determine
Okay. You both are under arrest for obstructing government operations.
Obstructing government operations.
That's correct.
Insistent on acquiring the phones as potential evidence, found themselves in a legal deadlock with the attorneys. The interaction grew heated as Ravel and Garcia asserted their understanding of the law, emphasizing the limitations of the warrant. Deputy Ashworth, adamant about executing the warrant, suggested the possibility of extending its scope. But Ravel and Garcia, steadfast in their defense, underscored the specificity of search warrants and the legal protections afforded to attorney-client communications. This confrontation was not just about a search warrant, it was a clash of legal interpretations, a dance on the tightrope of legal procedures. The attorneys, guardians of their clients' rights, stood as bulwarks against what they perceived as an overreach of police authority. For the deputies, it was a test of their ability to steer the complex waters of legal enforcement and the sanctity of attorney-client privilege.
I called over here they wanted a video of them doing a search warrant. Because they said they were going to run a search warrant on the car over there and they don't have any video. They wanted me to video and I was like, okay. They get them coming out of here. They've got video surveillance of them giving, or this guy, they run a search warrant on him for his cell phones in his car to retrieve the cell phones. He gives his cell phone to the female attorney to put it in her bag. They come out of here, they determined about the search warrant and everything like that, and said, hey, we need that phone that's out of that bag up there, and the lawyers have refused to give it up. So Sue placed both the lawyers under arrest for obstruction.
The legal conundrum in Blount County centered on the interpretation of a search warrant and the subsequent charges of obstruction against attorneys Victor Ravel and Megan Garcia. At its heart, this case hinged on the legal boundaries of search warrants and the definition of obstruction under Alabama law. The search warrant, specifically targeting Lloyd Edwards' person and vehicle, raised an important legal question. Did it extend to items transferred to his attorneys, particularly the cell phones deemed potential evidence? Alabama law stipulates that a search warrant must be explicit in its scope and execution. The warrant in question did not explicitly authorize a search of Edwards' attorneys or their belongings, which included the cell phones in question. This limitation was central to the defense mounted by Ravel and Garcia, who asserted that the warrant's constraints did not legally permit the deputies to seize items from their possession. The obstruction charges against the attorneys introduced another layer of legal complexity. Alabama Code 13A-10-2 defines obstruction as intentionally obstructing the administration of law by means of intimidation.
I want to arrest two lawyers for this charge. You sure you want to do this?
Are you subject to the law?
I am subject to the law.
Under arrest.
Okay. And this is, and you, and who are you?
I'm Sue Ashworth.
Sue Ashworth?
That's correct. And this is Brian Ratliff.
And you're arresting us under her orders?
Physical force or interference. Ravel and Garcia's refusal to hand over the cell phones, based on their interpretation of the warrant's limits, raised the question, did their actions constitute obstruction, or were they legitimately exercising their legal understanding and rights? The attorney's argument was rooted in the belief that their actions did not amount to intimidation, physical force, or interference, but rather a legal challenge to the deputy's interpretation of the warrant. This perspective highlights the delicate balance between law enforcement's duty to execute legal orders and the right of individuals, particularly legal representatives, to challenge those orders based on their understanding of the law. In this tangled web of legal interpretations, the actions of the deputies and the response of Edwards' attorneys set the stage for a judicial review of the search warrant's scope and the validity of the obstruction charges. The conduct of deputies Ashworth and Ratliff in the encounter with attorneys Victor Ravel and Megan Garcia warrants a critical examination, particularly in the context of legal justifications and the implications of their actions under Fourth Amendment rights. Initially, the deputies sought to enforce a search warrant on Lloyd Edwards and his vehicle.
We're not preventing you from
doing a search warrant on the car. And
so I just wanted to
I'm out here just
From the moment he's entered the courthouse, he's been under surveillance.
Yeah.
Okay? For the reasons of this search warrant. Alright? I'm sitting here and watched you and him and her.
Can't wait
Run
to get
the
about
elevator.
10 or 15 minutes. I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a password.
However, the situation escalated when they attempted to extend this warrant to include the cell phones in possession of his attorneys. The deputy's insistence on searching the attorneys and seizing the cell phones, despite the warrant's specific language, raises significant legal concerns. Their actions appeared to overstep the explicit boundaries of the warrant, venturing into a legally gray area that potentially infringed upon the Fourth Amendment rights of Mr. Edwards and his attorneys. The Fourth Amendment protects against unreasonable searches and seizures, requiring warrants to be judicially sanctioned and supported by probable cause.
Okay? That is evidence for this search warrant.
And you agree with me that you all served this search warrant on him subsequent to that, after that, all right?
Yeah.
After we left out the building.
Yes.
In this scenario, the deputy's interpretation of the warrant's scope seemed to disregard these constitutional protections. The insistence on seizing the cell phones from the attorneys, without clear legal authorization, suggested a misinterpretation or overreach of the warrant's authority. Moreover, the decision to arrest the attorneys for obstruction based on their refusal to comply with an arguably unlawful request further complicates the matter. The charge of obstruction, as defined under Alabama law, necessitates an act of interference, intimidation, or physical force against the administration of law. In this case, the attorney's noncompliance stemmed from a legal disagreement over the warrant's reach, rather than an attempt to obstruct justice. Public reaction. The public's reaction to this incident was overwhelmingly positive, especially towards Attorney Revelle. Internet users expressed admiration for his actions, with one user notably commenting, "Now that's a good attorney. Utmost respect for him. Would hire him for rest of my life."
Can you have Investigator Ashworth PX me at 288-1978?
288-1978. Can you call Deputy Ratliff? Yeah, 288-1978. They asked you to PX him.
This sentiment was echoed widely, as many applauded his steadfast defense of his client's rights, showcasing the importance of diligent and fearless legal representation in the face of challenging circumstances. In the aftermath of the controversial encounter at the Blount County Courthouse, attorneys Victor Revelle and Megan Garcia faced arrest and charges for allegedly obstructing governmental operations. This drastic turn of events stemmed from their refusal to comply with what they deemed an overreaching search warrant. Their arrest sparked significant legal discourse regarding the interpretation and application of search warrants and the boundaries of law enforcement authority. As the legal drama unfolded, the incident had far-reaching implications, not only for the attorneys, but also for their client, Lloyd Edwards. The confrontation and ensuing legal battles effectively sidelined Mr. Revelle and Ms. Garcia from continuing to represent Mr. Edwards in his ongoing case.
The deal, she told me and everything. And Brian walked out with them. I walked up here and whatever. This thing kind of...
thereby impacting his legal representation. Additionally, the incident prompted the filing of federal lawsuits against Deputies Ashworth and Ratliff, along with District Attorney Casey and Assistant District Attorney Scott Gilliland. These lawsuits brought to the forefront issues related to the abuse of power, violation of constitutional rights, and the potential consequences of legal missteps by law enforcement officials. The cases against the attorneys were eventually brought to trial, where a critical examination of the events and legal principles involved led to their acquittal of all charges. The judge's ruling underscored the overreach of the deputies' actions and affirmed the rights of individuals against unlawful search and seizure. Hey Larry, what's your take on this?
This case highlights the complexities of search warrants and obstruction charges under Alabama law. It emphasizes the critical role of the Fourth Amendment in safeguarding against unreasonable searches and seizures, showcasing the delicate balance between lawful authority and individual rights. Understanding one's legal rights and the limitations of law enforcement authority is essential. This incident serves as a reminder of the importance of responsible and knowledgeable legal advocacy in upholding justice.